In this video clip, we will continue to see the proposed amendment to the Constitution that's known as 20th Amendment to the Constitution. As we have seen up to clause 1 to clause 6. In this video clip, we will start from clause 7 of the proposed draft. Before we go to the clause 7, we will see the differences between the Constitutional Council as well as the proposed Parliamentary Council. Constitutional Council consisting of certain politicians and as well as some other members of the Parliament and members from the civil society. But in the Parliamentary Council now, as it is mentioned in the draft, Prime Minister, Speaker and leader of the opposition, plus there may be 2 nominees. Those nominees nominated by Prime Minister and leader of opposition. Then altogether 5 members are there in the Parliamentary Councils. Then the Parliamentary Council generally gives the observation in relation to the appointment of chairman as well as members of the commissions mentioned in the schedule. When you see the schedule, there are 7 commissions identified now: Election Commission, PSC, that's the Public Service Commission, National Police Commission and Human Rights Commission, and Commission to investigate the allegations of bribery and corruption, and the Finance Commission and Delimitation Commission. These are the 7 commissions identified. But when you see the list of commissions in the 19th Amendment, there are 2 more commissions now abolished. That's the Audit Commission as well as Procurement Commissions. Those 2 commissions are abolished by this draft. In addition to that, now when you see the officers or the office holders here may be appointed by the President on the observation given by Parliamentary Council. Those officers, when you see that, Supreme Court judges including Chief Justice and the Court of Appeal judges including the President of the Court of Appeal and GSC members. All these people may be appointed by the President on the observation given by Parliamentary Council. In addition to that, Auditor General and Attorney General and Parliamentary Commissioner for the Administration, that's the Ombudsman, and the Secretary General of Parliament also will be appointed by the President on the observations given by this Parliamentary Council. Now the system here, as we had in some very bad experience in 17th Amendment, because of that there's a specific provision in relation to the appointment of nominees, because now Prime Minister as well as the opposition leader nominate their nominees within 1 week time. If they fail to nominate, then the Speaker can nominate those nominees. In addition to that, here that's a very important point that we must see. Now in the appointment of chairman or the members or the office holders that we have seen now, relating to those appointments, President may seek the observation of these Parliamentary Council. Then the Parliamentary Council must give those observation within 1 week time. Suppose if the Parliamentary Council fails to give the observation within 1 week time, then the President can appoint as he wishes. Likewise, in addition to that, this Parliamentary Council, even the leader of the political party representing in the Parliament, not the independent group, only the leader of the political party. Also, the power is given to these political party, the leader of the political party, which represents in the parliament give their names to the speaker. In those cases, those names also will be sent to the or forwarded to the president. In that case, there may be nominations from the parliamentary council, there may be nominations from the any leader of the political party representing in the parliament. In those cases, the president may take consideration of these observations, and appoint. Now, there is no binding effect of this one observation. This is just an observation given by these either council or by any leader of political party representing the parliament. Then the president may consider when he appoints these chairman and the members of the commission or the office holders that we have seen. In addition to that, we must see another important point here. Removal also another interesting part here. Generally, removal, there may be separate laws may be there. If there is no separate law, the constitution may provide for these office holders. If there is nothing, then the president has the power to remove these office holders also. That also is specified in the constitution itself. Now we will move to the clause 7 of the proposed draft. Chapter 8 of the constitution hereby repeal and following chapter substituted therefore. Then the executive, the cabinet of ministers, as I explained in the first place, in the first video, the president shall be responsible to the parliament. That's specified in Article 42 of the proposed draft. And also when you see the Article 43 of the proposed draft, there must be a cabinet, and also cabinet collectively responsible and answerable to the parliament. That it was there even earlier period, even the present constitution or the same provisions are there, similar provisions are there. In addition to that, it is incorporated in the draft also, because the whole chapter removed, that's why they put it again in the Article 43. And also the president is a member of the cabinet, and also he is the leader or the head of this cabinet. That also mentioned. Then the appointment of prime minister also is specified. Earlier also is specified. There is no change at all. But again, specified or provided as it was earlier, or even the present constitution, the same similar provisions are there. Then the Article 44, that's very important, one of the important articles here. The president may assign to himself any subject or functions, and at the same time, the first thing is president assign the functions to some ministers, or the minister, they should be a member of the parliament. In addition to that, president may assign to himself any subject or function. In addition to that, 44.2, that's very important part here. 44.2 says, when you read this section, I think it's the proposed draft specify that section or provide that section here. President may assign to himself any function or a subject, and shall remain in charge of any subject or function not assigned to any minister. Then if there is a subject which was not assigned to anybody, then automatically it will come to the president. Right? That by this section, if it is not assigned to any of the ministers, there is a subject matter is there, then that subject matter should come under president. Then the present constitution, president should not should not keep or should not have any ministerial or ministries under him. But the proposed draft allows him to assign any ministerial function or the subject to him. That we have seen. And another issue here, the matter is in relation to the subject matter that we have seen. Then what happened is section 46 of this present constitution is repealed. The present constitution 46 restrict or limit present article 46 of the constitution restricts the number of ministers, deputy ministers and state ministers, that's known as non-cabinet ministers. But now that section is, the article is repealed, and the replacement is even the president may have subject matter. There is no limitation or restriction on the number of ministers in the cabinet. Therefore, this is open to the president to decide how many members in the cabinet and how many members in the cabinet of ministers or state ministers or deputy ministers. There is no limitation at all, because this proposed draft remove the provisions in relation to the restriction of number of members in the cabinet or even non-cabinet ministers and deputy ministers. Now that we have seen, now we will see. Now the another interesting part that I have noticed in the media is really what is said here. When the president appoints the ministers, if he considers necessary, then he can consult the prime minister. It was in the constitution, it is in the constitution, it will be in the constitution. That's because the existing one, the provision is there. The same provision even in the draft now. But the thing is, some media, so I have noticed one media said that now only necessary, then only the president must consult the prime minister in relation to the appointment of ministers, but not like that. Earlier also it was like that. Even the present constitution, it is like that. Where it is necessary, in his opinion, president thinks that he must consult the prime minister, then he can consult and appoint such ministers and number of ministers or deputy ministers or state ministers or cabinet of ministers. Otherwise, if he feels that it's not necessary at all, then he no need to consult with the prime minister. Then articles 47 of the proposed draft now say that prime minister or state minister or cabinet minister or deputy minister may be removed by the president. Now it's clearly said that even prime minister may be removed by the president. And also I would like to discuss these article 53 of the proposed draft. The prime minister or the minister or the cabinet of ministers or the non-cabinet of ministers or deputy ministers or secretary must take oaths. That's the general thing. Everybody knows that. Even to the public service, or if they join the public service, or you must take oaths, or even in attorney at law you must take oaths. But generally, under present constitution, the people must take two oaths. The first one under the oaths given under Schedule 4 and Schedule 7. But in the proposed draft, this is only required to take oaths under Schedule 4, not under Schedule 7. That's maybe an omission. I think they may correct it in the committee stage amendment that we will see later. Now we will move to the clause 8 of the proposed draft. that's in relation to the constitution of Public Service Commission. The Public Service Commission, as per this proposed draft, consisting of 9 members, and three members must have at least 15 years experience in the public service. That is new constitution of the Public Service Commission. Then the clause 9 actually amends the Article 57 of the Constitution. Now the appointment, transfer and disciplinary control and dismissal, all these matters in relation to certain categories of public officer may be delegated to the committee. But because of by this proposed amendment, the committee will be appointed by the cabinet, not by the commission. That's again the cabinet has taken the power to appoint these committees. Even the same way the clause 10 also amended, that clause 10 amends Article 58 of the Constitution. The same power in relation to the appointment and transfer and disciplinary control and dismissal, all these matters, all 4 matters, appointment, transfer, disciplinary control and dismissal of certain public officer may be given to the another public officer. That also now in the present constitution it may be given by the commission. The appointment of the public officer may be appointed or nominated by the commission. Now not like that. Again it has the power given to the cabinet to determine who must appoint, or the power of these certain officers must be given to which, or given to whom. Right, that part also again we will see. Then we will move to clause 11. Clause 11 of this draft amends Article 61A of the Constitution. It is not the big issue at all, but because the cabinet asked to go back to the 18 amendment, then this amendment made. Now generally the Administrative Appeals Tribunal has the power to alter, vary and rescind any decision of the commission. But the 61A says no commission or the tribunal, no court or tribunal has the power to inquire the decision of the PSC. But it impliedly subject to the power given to the Administrative Appeals Tribunal and the 126, that's the Supreme Court, when it hears the case, or the invokes if the people who have felt that their rights violated by the administrative or executive, then they can go to the Supreme Court. That's 126. Therefore, subject to those provisions only, this is given. But now, because of this requirement, they have removed the 59. That's Administrative Appeals Tribunal is removed. Then it goes as subject to the provisions of 126. Not the 59. 59 is the Administrative Appeals Tribunal. Whatever it is, there is no big change at all, because the Administrative Tribunal has the power to vary or alter or rescind the decision of the commission. Then 61E, that's little bit change now here. The President appoint the heads of the Army, Navy and Air Force. But earlier, with the approval of Constitutional Council, now it was repealed, and President has the full power and discretion to appoint Army, heads of the Army, Navy and Air Force. And also early in the present Constitution, with the approval of the Constitutional Council, can appoint the Attorney General as well as IGP, Inspector General of Police. Now that part also omitted or removed. Instead of that, now AG will be appointed by the President in this discretion without getting any opinion from anybody. And also retirement age is mentioned in the constitution itself, because AG and IGP may go up to 60 years. But now that provision is repealed, because again the establishment code will apply to the Attorney General and the IGP. Now finally in this video clip we will see the clause 13 also. Clause 13 amends section 65. In this one also again regarding the Secretary General of Parliament. Secretary General of Parliament appointed by the President on the recommendation of the Constitutional Council. Now that part also omitted or removed, and President in the proposed draft, the President has the right or the power, the discretion to appoint the Secretary General of Parliament without any observation of Parliamentary Council or anything else. That's the end of this video clip. Thank you very much.